Hey, this is Malika of Evanston Live TV, Channel 6 here, and today we have a guest that I am just in awe, absolute awe, because I think he is going to make some serious changes in our judicial system. I really, really believe that.
That's the hope.
And I know I'm supposed to be neutral on candidates, but I am really feeling Daniel Epstein.
Thank you so much. Thank you so much. I appreciate that.
You are running for Illinois Supreme Court.
That's right, yeah.
And first of all, I want to tell Evanston, he's a wild kid.
03. Still bleed orange and blue to this day and forever.
Okay, Daniel.
Yeah.
Now, when people think attorneys, you and I have talked a little bit about this. When we think attorneys, we think they can be a little corrupt, they can be a little dirty, and now you're wanting to be Illinois Supreme Court.
Yeah.
You aren't that kind of attorney.
No.
Your history, and people, please do your due diligence. You're that type of attorney who's really about the people and what's right. And so you're looking at becoming Illinois Supreme Court to bring change.
Yeah.
Speak to that. Tell the people what it is that you want to do.
Yeah. Well, first of all, thank you. That's so kind of you. And yeah, I'm running for Illinois Supreme Court, and what we're trying to do is reform what's called the Illinois Supreme Court rules and court rules. Those are rules of procedure, of evidence, of ethics. They're oftentimes viewed as really boring, kind of obscure stuff, but they have huge impacts on how we experience our justice system. So it's kind of like the source code behind the scenes that dictates our experience and whether we have bias and bad incentives and corruption in our court system. And so it's kind of hidden away, but when you actually interact with it, it has a really interesting and in some cases awful outcome for people who interact with the justice system. So what I want to do is work on those rules, reform those rules to bring them more into line with modern notions of truth-seeking and justice, into line with other jurisdictions that have fixed some of the problems that we're experiencing now, and to bring our court up to speed. That's what I'm hoping to do. And the Illinois Supreme Court is the only entity that can do that. Rules of procedure, evidence, and ethics, those are things that the Illinois Supreme Court has exclusive authority over. And but they have authority over other things that you wouldn't even expect. Design standards of courthouses, right? Those things oftentimes ignored, or people don't realize that the court has that power. But they have a huge impact on access to justice for undocumented people, for people with disabilities, for trans people. It's all this hidden stuff that has stayed the same way for a very long time because it's hidden. And so we're trying to expose it, reform it, and make it better.
One of the things you and I had talked about, we talked about several things that really touched a vein for me, and I think it will for many people out there. One, you had brought up racist jury selection.
Yeah.
That's a huge one.
Yeah.
Because I think there are a lot of people locked up right now who should not be there based off of the jury selection.
Yeah. Yeah, so it's a big problem, right? Because the way that jury selection works, the parties have the ability to exclude jurors. There's a big pool of jurors from which to select. It's called the veneer. And in the process of jury selection, you get to exclude them. And you're allowed to exclude some for no reason at all. You're allowed to exclude some for cause. But you're never allowed to exclude someone based on race or based on religion or national origin. But we know that people do. We know that people do. And we know that in reality, oftentimes people will try to get the whitest jury possible, right? And there's a legal tool to deal with that called a Batson challenge. But Batson challenges are essentially, not completely, but largely toothless. And so we have kind of remained vulnerable to racist jury selection for a very long time, and we don't have to be. I think we've kind of given up on trying to fix it, but there are ways that we can be experimenting with trying to get more diverse juries. And one of the things that we've talked about is just simply not allowing parties to actually see the appearance of the veneer, of the jury, potential
I like
jurors,
that.
right? So you've seen the show The Voice, right? You turn around and you listen to the person singing before you get to see them and make a judgment, kind of like that. And actually there's precedent for it from mafia trials. Back during some of the mafia trials, they had these things called innominate juries. And typically you get to know information about potential jurors. And that includes name and address and things like that. But folks were scared that if you gave the name and address of a potential juror in a mafia trial, that they'd be harmed. And so they created innominate juries where you don't get to know the name or address of the potential juror. You're shielded from that information, right? We can do the same thing, but with the appearance of the potential jurors. And what I'm suggesting here is a pretty big change. And so I want to be clear, we should experiment with it first, find instances where both parties consent to use this process, see how it goes, and then move forward if it's a good idea. But to just sit back and say, look, we have this huge problem that is unsolvable is unacceptable. We have to at least start experimenting and start to come up with new ideas of how to deal with this stuff.
What would you say is the reasoning behind just keeping things the way that they are?
Yeah, I mean, that's a great question, right? What's the best reason for the status quo, right? That's an outstanding question. I think folks have gotten used to it. I think that's really the reality. There's a British poet named G.K. Chesterton, and he has a great quote. And he says, the terrible thing about all legal officials, all lawyers, all judges, all police, all detectives, is not that they're wicked, many of them are good. It's not that they're stupid, many of them are quite intelligent. It's simply that they've gotten used to it. They no longer see the prisoner in the dock. They just see the usual man in the usual place. And I think that is a big part of how we've arrived at the place that we are, which is we have a lot of folks who have done it one way for so long that it's hard to see other ways of doing it. And so I think we need to shake things up, bring some fresh eyes and say, hey, actually there's other ways to do it.
Even when they know, being in the position that they are to change things or to see right from wrong, even in just seeing we're sending innocent people to jail.
Yeah, I mean, we know that that's the case, right? People plead guilty to things that they didn't do. The Innocence Project has done research on this. We know that that's a fact. There are many reasons why that happens, but to kind of throw up our hands and say, oh, well, that's just the way it is, unacceptable to me. Unacceptable. We deserve better, and we can do better. That's the thing. We can do better. And there are things that we can learn from other jurisdictions, and there are things that we can experiment with and try that I think can get us there.
Another topic we had discussed was depositions.
Yeah, that's a big one. Yeah, so there's depositions are a tool, a legal tool that allows you to get sworn testimony on the record. Right? We do them in civil cases when money is on the line, but we don't do them in criminal cases when liberty's on the line.
When your life is on the line.
When your life is on the line, that's right. You got to kind of wait for trial until to actually get stuff on the record, and for the most part. And that's a big problem because we lose a lot of information because a lot of cases don't get to trial. 97.5% of felony convictions in Illinois are guilty pleas. There's no trial involved there. And so because we don't have depositions and because we don't really go to trial very much, we lose a lot of information in that transaction. And that's information that we really need to expose pattern misconduct. Things like, police abuse that John Burge did for 20 years. He was able to do it for 20 years in large part because no one was able to get him on the record very much. We weren't able to cross-examine him, those kinds of things. And so we can kind of, we might not be able to stop people from doing a bad thing once or twice, but we should have a process in place that stops people from doing bad things for 20 years. And depositions by right in criminal cases is a way we can do that. We already do them in civil cases. Like I said, other states do depositions by right in criminal cases as well. Florida, Indiana, there are others. And we can do it too.
Is that why I have such a hard time getting some city officials to interview on video?
It might be.
Here?
It might be.
It's like kind of a deposition in a way.
The record's a dangerous place. That's right. Well, look, but there's something to that, right? Which is a lot of people like to talk about transparency, but what does it actually mean, right? Where are the teeth? Where does the rubber meet the road? How do we do transparency? Not just how we talk about it, but how do we do it? And depositions are how we do it. And I know that from I came up with this idea from experience, unfortunately, where I was representing an individual who who was accused of attempted murder here in Cook County. And the state was using DNA evidence against him. And my job was to learn everything I could about DNA and to mount his defense. And so I read everything I could get my hands on. We hired a forensic scientist. I interviewed the state's DNA analyst, and what we found was terrifying, which is that the state was using a faulty DNA machine, right? Terrifying, right? Because who knows how many people were harmed by this thing. But I was optimistic because I was like, look, we're going to go to trial. I'll cross-examine that DNA analyst. We're going to expose the information. We'll talk, we'll find out, we'll spread the word about this bad machine, and they'll have to retrain the DNA analyst, and I'll have to fix the machine, and no one else will be hurt by it. And I do a little bit more research, and I find out that in Illinois, our forensic labs get extra funding when they produce an analysis that ends in conviction. And I do a little bit more research, and I find out that our courts get extra funding when they convict, right? And I'm offended by that. Because step one in justice is impartial courts, right? And if there's a financial reward, not for finding truth, but for finding guilt, it really cuts into impartiality, right? So, but I'm still optimistic. We're going to go to trial. I'll expose that stuff too. That's how it's supposed to work. But that's not how it worked. Because what actually ended up happening is we went back into judges' chambers under something called Illinois Supreme Court Rule 402. And under that rule, what happens is the state kind of previews its trial, and the defense kind of previews its trial, and the judge previews the sentence that he would give. So the state says, Judge, this is what we're going to show at trial. We say, Judge, this is what we're going to show at trial. And then the judge says, well, based on what you've told me, I think an appropriate sentence were I to convict would be 70-something years. And then you walk out into the hall, and the prosecutor pulls you to the side and says, all right, you heard the man, 70-something years. But if you plead guilty, I'll ask for 20-something, right? And so our client has to decide, do I assert my constitutional right to a trial and risk dying in jail, or do I take the plea? And he takes the plea. And that ends the case. And what that means is I don't get to put that DNA analyst on the witness stand. I don't get to cross-examine him. I don't get to expose the bad machine or the systemic funding issues. That information disappears, right? If we had depositions, that information would be on the record, right? But we don't. We have to wait for trial to get that stuff on the record. And so it's really important. And I can tell you, not just as just an abstract idea, but I knew that person, right? So these are not just ideas about how to change, but they're people. And it's really important that people understand that the reason I have a sense of urgency is because, I show up to court and I see people and their families who are getting hurt by this stuff. So I want to make sure that it's tangible to people.
How did you become, you're from Evanston, which is a great place, so that would explain why you're a good attorney and you have a good heart and
That's
you care for people and community.
Yeah.
But how did you escape being sucked into an attorney who would say, well, you heard him, 70 years.
Yeah.
Why don't you just take this plea, let him go to jail for 30 instead, even though he's innocent.
Yeah. I think part of it is that I've decided to run fairly early in my career, right? Some people view that as a disadvantage. They say, oh, well, you haven't done it for long enough. You haven't paid your dues. But the flip side of that is I haven't gotten used to it. That wound is still open for me. It hasn't scarred over. These problems still offend me. And so I view it as an advantage. And there's one person that is kind of a North Star for me in this is a guy named Terry Hake. We've never met, but Terry Hake was one of the people most responsible for the advancement of our justice system in Cook County. And he was an individual who wasn't an attorney for very long, but when he stepped into the Cook County court system, what he saw was judges taking money to deliver outcomes in cases, right? And he found that unacceptable. He was surrounded by people with decades of experience who just said, yeah, that's how it works, right? That's how you just got to deal with it, right? They're judges, they can do what they want. You just got to work around it, right? And he said, no, that's not acceptable. And he ended up working with the federal government to expose that problem in what became a massive federal investigation and prosecution called Operation Greylord. It was a huge, huge deal. It went on for years and years and years. We put judges in prison because of this. And we went through this enormous and traumatic experience in reforming our courts to take money out of courts to make sure that judges didn't consider anything other than truth when making their decisions. And yet today, when courts convict, they get extra funding, right? It's just in statute. Rather than being, under the table, it's in statute. And, I take after, I hope that I bear some similarity to Terry Hake in some ways in saying, look, the wound is still open. This is new to me. It's not something that I just want to get used to. And I think we got to act now to change it and make it better.
When I think of the judicial system, I just think it's like boxing a mountain. Like boxing a mountain, and I have friends and relatives who, the situation that you described, not 70 years, but they lost years, for crimes that they didn't do.
Yeah.
And you almost feel hopeless and powerless, especially when you don't have money.
Yeah. Yeah, it feels like the fix is in, right? Yeah, and you have to make this terrible choice, how do I manage my life? Yeah, and I think you're in good company in saying it feels like boxing a mountain. I'm trying to change that, and when I first started campaigning, I was telling people, I was going around the county and talking to people and saying, look at these terrible things that are happening, right? These are telling stories, shocking stories, like some of the ones that I just told you, and I kind of left them saying, yeah, the justice system's broken, right? And that's not how I want to leave people. What I want to leave people with is the opposite. They already believe that the justice system is broken. I'm not convincing them of that, right? They just don't know how. But what I'm trying to say is, look, this is how it's broken. But what that means is if we can identify the way it's broken, we can fix it. And we really can. It's not like boxing a mountain, right? It's like opening up the fridge and smelling that something's rotten, right?
And taking it out.
And then saying, this is what it is. Let's get rid of it. Let's replace it, right? It's the cream cheese. Get rid of the cream cheese, right? We can fix it. We really can. And it's
well, you've identified it, so what's the move to get rid of the cream cheese?
Yeah, right. Vote for me on March 17th, 2020, right? No, it's a lot of things. I mean, it's a broader movement. Part of it is we need a friend on the court who really focuses intently on rules reform and who really understands in a deep way kind of the systemic reforms that we need to affect. But it's a bigger movement than that. We really need folks in the public understanding this and taking a look at it. We need to build something that we pay attention to even when it's not election season. But the first step is getting a friend on the court, someone who can really kind of lead this charge and say, hey, when you're ready to make a rules change, so am I, and let's do it.
So, expert witness.
Oh, yeah. Yeah.
I love the way you broke that down to me.
Yeah.
How that all works. In my mind, I don't know if I've watched too many movies or what. My friends and family, many of them didn't even make it to trial.
Yeah.
Pretty much.
Right.
So I really didn't. I haven't really witnessed myself how the process is really played out to the very, very end, because it just seems like the book is thrown at them just right away.
Yeah.
Explain that part of it.
Yeah. So broadly speaking, there's two different types of witnesses. There's these things called percipient witnesses. They perceived something that happened. They smelled, tasted, heard, saw something. And then there's expert witnesses. And they didn't smell, hear, taste, see anything. What they really bring to the table is a technique or an expertise that they can use, they can apply to the evidence to help the court understand what's going on in the case. And sometimes those are economists to help us predict what damages would be, or doctors to say, this is what the standard of care should be, and this is versus what the doctor did, right? And sometimes they're forensic scientists, right? And in those cases, they have to, in order to qualify as an expert, they have to satisfy something called the Frye test in Illinois. And the Frye test says, you can only qualify as an expert if you use a technique that is, quote, generally accepted in your field, right? It doesn't sound like a big problem. It's a big, big problem. And here's why. Tarot card readers use techniques that are generally accepted in their field, right? All kinds of people use techniques that are generally accepted in their field, but they're not reliable, right? They're unreliable, but generally accepted. And at the federal level, in order to qualify as an expert, in many states, you have to follow something called the Daubert test, satisfy something called the Daubert test, and you have to prove that you're reliable. So let me show you how this pans out, right? So I represented an individual who was put behind bars for murder for decades based on what's called bite mark science. Sometimes it's called forensic odontology, which is a forensic odontologist is basically a fancy way of saying a dentist. And what they claim to be able to do is look at an injury on a body and tell you whose teeth made that injury, or if teeth made that injury, right? So they say, okay, I see a mark on the arm, and you've now shown me the suspect, and I'm going to take a dental mold of that suspect's teeth, and I'm going to make images and compare the images between the injury and the teeth, and be able to tell you whether or not those teeth are consistent with the mark made on the body, right? And they did this for years and years and years, and put a lot of people behind bars. And only now that we're doing research are we finding out that in best case scenarios, they're accurate about 2% of the time. Right?
Oh my goodness gracious.
They qualify as experts. They use a technique that is generally accepted in their field, but it's not reliable. Right? And they're not alone. There are other people that do similar things, right? It's a new thing all the time. But we can protect ourselves against that by literally copying and pasting the federal rule into our own and adopting a standard that requires reliability. That's the kind of rules reform that I'm talking about. It's hidden. Not many people know about it. It's kind of obscure, but it has a huge impact on lives.
Wow. I'm really, you're affecting me right now because I'm thinking of all the people just locked up over things like this.
Yeah. Yeah, me too.
And it took this student from ETHS to say, you know what, we should change this.
Yeah.
Has anyone before you tried to make these changes?
Yeah, some of them. I mean, I don't think that there's been a judicial candidate who has run with a platform pushing for rules reform the way that we're doing that. I think that's new and innovative. But there are groups out there who have pushed for different types of rule changes. Chicago Appleseed has pushed for certain rules changes, Chicago Council of Lawyers, Chicago Community Bond Fund, Illinois Justice Project. They're trying to do things like end cash bail through rules reform. That's a big one. Groups have tried to change rules that would protect us from judicial corruption. That
doesn't seem to be working.
Yeah. Well, right. There's in Illinois, appellate and Supreme Court justices get to determine their own conflicts of interest, right? So if someone says, hey, you have a conflict of interest, you're invested in one of the parties. The person who gets to decide whether they get to decide that case is the person with the alleged conflict of interest, right? So that's not how it works even at our own trial court level. It's not how it works, at a law firm or in many other industries. But for our appellate and Supreme Court justices, the justice themselves, they are trusted to give a truthful answer and say whether they have a conflict that allows them to be impartial in a case. Big problem. We should have a disinterested person making that decision, but we don't. We can change that through rules reform. So it's stuff like that. And, there's a lot of opportunity.
Goodness, okay. It's almost like a horror film.
No, we can fix it.
It just never ends.
I'm describing how it already is, right?
Right.
And
how it's been for
a very long time. And so I truly do want to provide this optimistic message, which is we can fix it. We really can, right? So, when I'm telling you this stuff, it's shocking because of the details, but I'm telling you, I'm just describing reality, right? I'm describing something you already kind of know. The thing that I want to bring that's new is we can fix it. That's the new message.
That it can be fixed.
That's right.
Okay.
Don't despair. We're not condemned to this fate. We can work together to make it better.
All right. Reducing bias.
Yeah. There's a lot of ways we can do that. I mean, one we already talked about one of them, but which is we can make it so that courts don't get extra funding when they convict. Right. Forensic labs don't get extra funding when they produce an analysis that ends in conviction. That's a pretty good way to reduce bias, right? We talked about jury selection, right? That's a good way to reduce bias as well. But there's another one that I think is worth talking about, which is sentencing guidelines. So sentencing guidelines are, well, let me back up. In Illinois, we have sentencing ranges for different types of crimes, right? So a Class X felony, you can get sentenced anywhere from 6 years to 30 years, right? That's a huge range, right? So let's go back to that story where we were, you go back into judge's chambers and he says, if I were to find you guilty, I would probably give you a sentence of, X number of years. And then you go out into the hall and the prosecutor says, I'll ask for Y number of years, right? If it's a Class X felony, the judge has leeway to rationally say, hey, if you go to trial and I find you guilty, I'm going to give you 30 years. And then when you go out into the hall, the prosecutor will maybe say, okay, well, I'll give you 6 years, right, if you plead guilty. That's a huge range, right? And so that lends itself to that coercive environment where people are forced to face a very difficult choice. Do I fight this thing that I know I should win, or do I plead guilty, right? And we can reduce that by creating sentencing guidelines. So rather than saying your range is 6 to 30, the statutory range remains 6 to 30. But what you do is you create guidelines that says, but in almost every case, you should really be, 10 to 12. That's really the range that it should be in, right? And you have these things called aggravating and mitigating circumstances. You can go upwards of 12 if the crime that you are convicted of was really heinous, or you can go downwards from 10 if there are reasons why you did the thing that you did and they're understandable or something like that, right? Those are called aggravated and mitigating circumstances. But for the most part, stay in this narrow band. And that's really important because if you are concerned that a judge or a court is biased, right, you might suspect that someone who looks like me gets closer to that 6. Right? And someone who looks like you might get closer to that 30. And so if we want to reduce that inconsistency, reduce that opportunity for bias, then what we can do is create these sentencing guidelines where we say, really, for the most part, we should be in this narrow band so that we're not so, we don't get such different outcomes just based on factors that really shouldn't be considered, right? And at the federal level, they do this. In federal courts, they do that. In our state courts, they don't. We can do it. We can make that change. We can reduce bias. We can reduce the opportunity for bias.
Now, I know your history, you've done a lot of pro bono work. I mean, you're that attorney who's really had a heart for the people. Your history, I would love to, be a fly on the wall when you're sitting with one of your clients and you know that you can get their freedom if we go to trial. What is that like for you to sit across the table from your client and they just have no hope? They'd rather just take the plea.
Yeah, I mean, the reality is that these cases are, they're just hyper complicated, and there's I've never experienced an example where it's a clear-cut case. If you fight it, you're going to go free, and if you don't fight it, you're not going to go free. And that's part of the dance that occurs, right? A lot of these bad outcomes live in the uncertainty of real cases, and so it's always a really complicated situation. But I can tell you, I mean, I understand the thrust of what you're asking, and it's an extraordinarily difficult conversation, right? Because ultimately, as empathic a person as you can possibly be, you can't make that decision for someone. It's their life, right? And you can't gamble with someone else's life. It's their decision. And the best that you can do is make sure that they're as informed as possible and that they understand the risk that they're taking one way or another. And you give them the best shot that they possibly can. But I've been on the other side of things too, where I get the opportunity to say, look, I saw that you were harmed and you were wronged and you were imprisoned wrongfully. And I've been a part of cases that got people out by reversing that down the road. And one of the cases that I took was a case springing from a murder in 1999 in Markham, Illinois. And that case was one in which the judge found the individual guilty based on no evidence at all. So he acknowledged that the state's case was weak, that he said the state's case doesn't make sense, there's nothing to it, but here's what I think happened. And then he kind of like spun a story from nothing, right? Guilty, 25 years. And our client appealed and lost. He appealed from the Illinois Circuit Court to the Illinois Appellate Court, lost, petitioned to the Illinois Supreme Court. Illinois Supreme Court wouldn't even take his case. And he's saying, look, you violated my constitutional right. You can't find someone guilty based on no evidence. Right? It seems like a good argument, right? Illinois Supreme Court wouldn't even take his case. He then does something called a habeas petition to the Northern District of Illinois, which is a federal court. He loses again. He appeals up to a federal appellate court, the Seventh Circuit. That's when we take the case. We win. And the state then appealed up to the Supreme Court of the United States, and we followed the case up to the Supreme Court, briefed it, argued it, and then ultimately the court did something called a dig. They dismissed as improvidently granted. They said, you briefed it, you argued it, But ultimately, we don't think that we should have taken the case in the first place, even though we accepted it. We made a mistake, basically. And so return to the Seventh Circuit Federal Court of Appeals, take that the result of that case, and in that case, we won. So the conclusion was, yes, this person's due process right was violated, and they didn't get a fair trial. And that guy's walking free today. So the situation that you described is a terrible one, and it happens a lot. But there's also some success stories, even though it took, I think, 17 years to turn that one around. That's an amazing feeling to be able to do that. An amazing feeling. I still carry it with me now.
Tell us of some more, because I love a good fight story. No matter how long it takes, you didn't give up.
Yeah.
You didn't give up.
Yeah, I mean, and in this case, there are cases that last an incredibly long time. I mean, I've worked on cases that were literally in court longer than I've been alive. Those are civil cases, but cases that were decades old. The court takes a long time sometimes to finally get at the right result. But there are things that we can do to hopefully reduce that too. To make things more convenient, to move things along more efficiently. And we've actually suggested some things on our platform, using technology to create more efficient courts, right? So I'll tell you a story about, one time I talked to a group of people who were laid off from a factory in Cook County. And they were all undocumented. And I asked them, how many of you have ever experienced wage theft? And every single one raised their hand. And I asked, how many of you have sued the people who stole your wages? And every single one lowered their hand, right? And the reason is they won't set foot in our state civil courts because they're afraid that if they do, ICE will be there. And they'll arrest them, they'll detain them, they'll deport them. And they're right to be afraid because it's happened in courts throughout our country. And that's unacceptable. That's basically a subsidy to wage thieves and abusers, right? Who know that they won't be sued by the people they're stealing from and abusing. There are things that we can do to address that, right? We can use technology to address it. We can allow people to bring a case without setting foot in court through the cameras on our phones and our computers. Jurisdictions across the country have started to do this already. They're already in process, right? And we just haven't done it yet. And so we're still in a situation where people who have legitimate claims that require a legal remedy nevertheless aren't able to get it. Big problem. And it's not just for undocumented people, it's for people with disabilities who can't, make it to court, for people with, child care responsibilities or jobs that they can't take off of. Think about how nice it would be to be able to, instead of having to go to traffic court to fight a ticket that you didn't deserve, you can just get onto your computer and appear, and you don't have to worry that a judge is going to call your case on time or whatever.
That would be wonderful.
Right? We can make it more convenient, more just, more fair. We can have our cake and eat it too, is what I'm saying. It's not a pipe dream. It's real. It's already in place in places.
Oh, that would be wonderful.
So, there you go.
Well, we need you.
I appreciate that.
We need you, Daniel, definitely. Yeah, we need you, because you've opened my eyes to some things that I didn't even think about. And I think some of us just, as much as we fight, we still feel this power, like we're powerless. And in talking to you, I feel like there's hope. You can actually change these things.
Yeah. We're not condemned to this fate. There is hope. Absolutely. We can fix it. That's right. Yeah, I'm glad to leave you with that feeling. I don't want to leave you with the feeling like we're condemned, right? I want to leave you feeling more powerful.
I feel very, very, yes, I feel powerful.
Good.
Yes, I do.
Me too.
That's that ETHS thing
That's
going
right.
on.
That's right. Absolutely.
Yes. So what's the one thing you really want to get out to the people who Daniel Epstein is and who he will be as Illinois Supreme Court?
Yeah, I think, the number one thing is, I want to convey this. Even the most fair person can't achieve justice in an unfair system. If we don't fix the system, then it doesn't matter who you select. They can be the most fair person in the world. We're not going to get to where we need to go. We need to fix the system. We need systemic reform. We need to reform the rules. That's the number one thing that I want to get across, and we can, right? And that it's something that we can actually achieve, right? The number two thing I want to get across is that we have an event coming up September 22nd here in Evanston at the Orrington Hotel at 3 p.m. Entrance is free, food is free. There's some parking available. I don't know if that's free or not, But
I doubt it.
I doubt it. But come anyway.
All right.
It'll be a good event. It's going to be high energy. A lot of folks are showing up, and a lot of folks who you know from Evanston are going to be there and are hosting. And we're going to talk about a lot of this kind of stuff and more. And so hopefully we'll leave with a room full of people feeling more powerful. And I think that's a great place to start. So September 22nd, 3 p.m., Orrington Hotel.
I will be there. I know everybody else will be there. We'll come with questions. And yes, you have given me hope. God, I wish you need to be around for my relatives, you know, who just, the system just really did them.
Yeah.
And so I'm feeling very, very good right now. So
I'm grateful.
thank you for your time
Thanks
today.
so much. I really appreciate you. It was wonderful.
Daniel Epstein, Illinois Supreme Court.